there's a development which I do not know if you are administratively
Can I read my ruling first? And then you can make application.
It was not an application. No. Just wanted to bring, but I think it's in order. We'll
let me read my ruling first.
Fair enough.
And then
fair enough.
That is my ruling. On 2nd February, the applicant filed an originating notice of motion. First one was 2, 10, 19, 20, 22, 25, 27, 49A, subparagraph A, 49(1), subparagraph A and I, and 49, subparagraph 1, and subparagraph F1, I, and H, and Articles 159 and 259 of the Constitution and Section 123 of the Criminal Procedure Code, seeking several orders from this court. The most important of which was a prayer that the applicant be released on bail or bond or be promptly taken to court to answer whatever charges that the respondents may prefer against him. The applicant further prayed that notwithstanding any of their foregoing prayers, the court should admit the applicant to anticipatory bail pending his production before the court. The application is supported by the next affidavit of Nelson Harvey and Dai, the advocate for the applicant. In the affidavit, learned counsel expressed fear that the applicant's life would be or is in danger if the court did not issue an order to secure his freedom pending investigations that the second and third respondents were conducting or intended to conduct. It was determined that the applicant was apprehensive that he would be subjected to torture and physical abuse, especially taking into consideration the manner in which the applicant was forcefully arrested and his property destroyed. The applicant was apprehensive that his fundamental rights, as enshrined in the Constitution, would be contravened if the court did not act appropriately to secure the applicant's freedom on anticipatory bail, pending his arraignment before court to answer whatever charges that may be brought against him. When the applicant's counsel appeared before this court, that is Justice Wakiaga, under certificate of urgency, the court directed that the applicant be released on anticipatory bail, cash bail of 50,000, pending his appearance before court on the hearing of the application in the parties on 5th February 2018. The court ordered the respondents to be served immediately. As a caveat, the court ordered that should the respondents charge the applicant with a known offense, then the applicant should be presented before court as soon as possible. Immediately upon the order was issued, a cash bail of 50,000 shillings was paid on behalf of the applicant. From the evidence on record, it was evident that the respondents were duly served on 2nd February 2018. However, the applicant was not released from police custody. When the matter was listed before this court on 5th February 2018, counsel for the applicant expressed concern as to the applicant's safety. It was feared that the applicant may have been harmed, taking into consideration the fact that neither his advocates nor family members had seen him since his arrest and detention by the police. From the submission made by the learned counsel for the applicant, it was apparent that the applicant was kept incommunicado and was not able to communicate with his advocates. The whereabouts of the applicant was unknown since the police were not willing to disclose where he was being detained. Mr. Milimani, for the Director of Public Prosecution, was able to shed any light as to the whereabouts of the applicant. Indeed, Mr. Milimani told the court that he was unable to find any response to the application because the police were either unwilling or had refused to give him any assistance for which he was to make representation to court. This court was concerned that the respondents appeared to be reluctant in complying with the orders that was issued by this court. Was reluctant in complying with the orders that was issued by this court, directing the applicant to be released on anticipatory bail pending further investigations, if at all, or pending his arraignment before court for whatever charges that may be brought against him. This court also took into account the legitimate concerns raised by the applicant's counsel in regard to the safety and welfare of the applicant, noting that no one had seen the applicant since his arrest and detention by the police. It was in light of the above facts that the court directed the second and third respondents to appear personally before this court and show cause why they should not be punished for being in disobedience of the orders of this court. The main concern of this court was that the second and third respondents were required to produce the applicant before this court so that he could be dealt with in accordance with the law. Of course, this court was aware that the second and third respondents, were the second and third respondents to present the applicant before a court of law, then the concerns of the applicant's counsel would have been addressed in that the applicant will no longer be in the custody of the police, but under the custody of the court, which is mandated by law to deal with the applicant in accordance with the law. The court directed the Director of Public Prosecutions to serve the second and third respondents to be present before the court today, that is 6 February 2018 at 9 a.m. with the applicant. When the court convened on 6 February 2018, it was informed by Mr. Mutuku, the Deputy Director of Public Prosecution, that the applicant was presented before the Kajiado Chief Magistrates Court and had been charged with 3 offences. The court was shown a draft charge sheet. The applicant's counsel, specifically Dr. Hamino, was not impressed by this turn of events. He objected to the decision made by the respondents to charge the applicant before the Kajiado Chief Magistrates Court, an inferior court to this court, yet there was a pending order of this court that the applicant be produced before this court, for this court to deal with him in accordance with the law. He further submitted that the respondents must abide by the order issued by this court that required the second and third respondents to be personally present before this court to produce the applicant to deal with in accordance with the law. This court, upon hearing the parties, formed the view that it could not substantially deal with the issues raised here if it was not confirmed that indeed the applicant had been charged at the same court. It adjourned the matter to 12 noon when it was duly informed that indeed the applicant had been presented before the Kajiado Chief Magistrates Court and had been required to take a plea. That confirmation having been made, the issues for determination by this court are threefold. First, the effect of the orders that were issued by this court requiring the applicant to be released on a person bail on 2nd February 2018 and reiterated by this court on 5th February 2018. As regards this issue, it was submitted on behalf of the applicant that since the respondents had acted in blatant disregard to the orders of this court, then any charge or charges brought against the applicant could not be sustained in view of the contempt of the orders of this court by the second and third respondents. The applicant further argued that this court had the mandate and jurisdiction presented by the Constitution that required it to uphold and protect the human rights, fundamental rights, and freedoms of the applicant. In a sense, the applicant was saying that this court should disregard whatever charges may be brought against him because the applicant's fundamental rights and freedoms had been breached. In response to this submission, it was the respondent's case that since the thrust of the applicant's application was in the nature of habeas corpus, and since the applicant had already been produced before court, then the application had been spent. Whatever remedies the applicant was minded to seek then, he ought to file a constitutional petition to invoke his fundamental rights and freedom, or file civil suit for damages on account of breach of his constitutionally sanctioned rights and freedoms. This court has carefully evaluated the above arguments. It was clear to this court that the second and third respondents acted in clear breach of the orders of this court issued on 2nd February 2018 that required them to release the applicant from their custody, pending further orders of this court on 5th February 2018. It is not for the respondents to interpret the legality or the veracity of the order issued by this court. It is not open for the respondents to choose whether or not to comply with the orders issued by this court. As public officers, the second and third respondents are required to lead by example by obeying orders issued by the court. The second and third respondents cannot afford to enforce the law by breaking the law. They acted clearly in contempt of the orders of this court by detaining the applicant in breach of the orders issued by this court. This court was concerned that the second and third respondents appear not to appreciate the seriousness of their action in failing to comply with the orders of this court, hence its decision to summon them to appear before this court. Eventually, the second and third respondent did produce the applicant before a court of competent jurisdiction. It is this court's considered opinion the application achieved its objective of securing the production of the applicant before a court of competent jurisdiction. The applicant's remedy for unlawful detention lies in filing an appropriate suit for damages for breach of his fundamental rights. This court does not have jurisdiction to terminate criminal proceedings brought by institutions mandated by the Constitution to bring criminal charges before courts. This is a position that has judicial approval in the Court of Appeal cases of Dennis Lescarlos Shea versus Republic. It's reported in 2015 volume Kenya Reports, Electronic Kenya Reports, and John Kamau Mbugua versus Republic, reported in the 2010 volume of Electronic Kenya Reports. In the High Court Judicial Review Application number 78 of 2015, Republic was the Director of Public Prosecutions and another ex parte, Chairman Lal Rajlal Kamani and two others. Justice Odunga held at paragraph 143 of the judgment in respect to a judicial review application dealing with more or less the same issues presented before this court, and I quote, "This court in determining judicial review proceedings ought not to usurp the constitutional and statutory mandate of the respondent and the interested party to investigate and undertake prosecution in exercise of the discretion conferred upon them. It was in recognition of this fact that the House of Lords in the case of Director of Public Prosecution versus Humphreys, reported in 1976, Volume 2 of All England Law Reports at page 497, and specifically at page 511, cautioned that, and I quote, "A judge must keep out of the arena. He should not have or appear to have responsibility for the institution of a prosecution. The functions of prosecutors and of judges must not be blurred. If a judge has power to decline to hear a case because he does not think it should be brought, then it soon may be thought that the cases he allows to proceed are cases brought within his consent or approval. If there is a power to stop a prosecution or indictment in limine, it is my view a power that should be exercised in the most exceptional circumstances." End of quote. As earlier stated in this ruling, the thrust of the applicant's application was to secure his production before a court of competent jurisdiction, and thereafter to secure his freedom by being granted firstly anticipatory bail pending his presentation before court, and secondly, bail. Can you control those persons? Officer, can you go and control those people? Sorry.
This might make it worse.
Okay. Secure his freedom by being granted firstly anticipatory bail pending his presentation before court, and secondly, bail pending his trial as provided under Article 49(1)(h) of the Constitution. The applicant shall be at liberty to seek appropriate remedy in a constitutional petition or a suit for damages for breach of his fundamental rights and freedoms during the period that he was detained in breach of the orders of this court. In that regard, the applicant must appear before the court that he has been charged, and if he wishes to challenge the decision of that court to try him, he is at liberty to file an appropriate application before the appropriate court. The second issue for determination is what remedy the court should offer to the applicant now that he has been produced before a court of competent jurisdiction. This court is of the view that since this court has directed that the applicant be released on anticipatory cash bail of 50,000 shillings, then if he has not yet been charged, he shall so be released pending his appearance before the court that he has been charged. If he has already been charged, then the trial court should consider his application for bail pending trial, subject to the caveat that this cash bail shall not be more than Kenya shillings 50,000. The third issue for determination is whether the third and second respondent's appearance before this court will be necessary now that the applicant has been produced before a court of competent jurisdiction. In view of the sentiments expressed above by this court to the effect that the applicant's rights to sue the second and third respondents for illegal detention has accrued, and in view of the fact that the applicant has already been produced before a court of competent jurisdiction, it may not be appropriate for this court to require appearance of the second and third respondent because it will not serve any useful purpose. For the above reasons, the applicant shall be allowed in terms of the orders issued by this court in their foregoing paragraphs. It is so ordered. So those people shouting, Miguna will be released. So there is no problem. But control your supporters, please.
This
is a court of law.
Yeah.
Is that okay?
No, but that's not the way we should behave.
Yeah.
Yeah.
This is not a political rally.
That's the way.
This is a court of law. The prayers you have sought have been granted.
They have been given.
So there should not be any cause for alarm.
On our part, we would like to say to your Lordship, thank you very much.
You are most
grateful to you for your diligence, for your perseverance, and for having us to far. Yes, much. Yes. My land friend, Mr. Amolo, would like to say something.
Yes.
But my Lord, as a matter of good manners, I always think I received good manners.
Yes. Yes, you are.
Many did not.
Yes, you
did. But I always think that I received good manners. I was taught good manners.
Yes.
My Lord, with your permission, I would like to acknowledge the presence of our Raila Odinga here. My Lord, I would also like
You're most welcome.
Thank you. My Lord, I would also like to. It's a privilege. Yes, my Lord, we are very happy and we remain most grateful to you for taking the trouble to come. We know how busy you are, and for you to court, I wish a number of other people in high positions could learn that courts have to be respected, and you have to come and listen to judges when they are reading their judgments. My Lord, I would also like, if you may permit me, I would like to acknowledge the receipt for my learned lady friend, Miri Odiambo. Is also here. She's here.
I'm privileged to be her classmate.
Finally, my Lord, I would like to acknowledge the presence of my learned friend, Honorable Senator Mutula Kilonzo, who is also here.
He has appeared.
Again, my Lord, we thank you. My Lord, there's only one small matter in which you may probably try to give me, or to give some kind of direction. Strictly speaking, the applicant will be making appearance before this court as a first lawful appearance.
He's being brought here.
Yeah, he's coming.
But I've already released on anticipatory. Well, he's on the. It's my ruling. Yeah.
Oh, you have already released him?
Of course.
Yeah. But my Lord, you still have jurisdiction.
No, I've already released him.
I see.
If you heard what I said,
yes.
If he has not been charged before the court,
yes.
I've already released him.
Yes. Yes. Okay.
If he has been charged in court, I've already released him.
Yes. My Lord, my Lord friend, Mr. Honorable Amaro, would like to say something. Yeah.
My Lord, first of all, my Lord, allow me to address the audience. Please, ladies and gentlemen, allow us to handle this. Please, Yes. Please, allow us to handle this. Now, my Lord, I apologize that I had sought to address you earlier. But my Lord, it's because I had wanted to bring to your attention a certain set of facts that arose when my Lord retired to do your ruling. And it is this, my Lord, that while the suspect was presented in Kajiado Court to take a plea, that court, in deference to your jurisdiction, suspended the plea. The plea was not taken and made two orders. One, that the police do produce the accused suspect before the High Court at Nairobi before 3 p.m. today. Two, that once the issue pending are conclusively thrashed out by the High Court, the accused can be brought to this court for plea on 14th February 2017. My Lord, that accords with your order except in one respect. In your order number 2, you proceed to give the accused person, now accused person, bond to the extent of what was deposited. The only thing that is pending is that the accused person has not been brought before you so that he can be released. Our fear, which is legitimate, is that my Lord might retire and we might be where we were last Friday. Yes, my Lord.
I know where you come from.
Yes.
You are addressing a constituency.
Yes.
But ourselves, we are addressing them.
Yes, my Lord.
I will not get out of this court.
Yes.
Until
Yes, my Lord. Thank you. That is what I was going to try. Yes. Most obliged, my Lord. Most obliged.
I'm told
in
it.
anticipation, and in anticipation,
Yes.
in anticipation of what you have said, I have already issued orders.
Lovely.
I'm being told yes, the gross
Where is it?
somewhere in the courtroom, in the courthouse, not courtroom. What I propose, my lord, is if you may adjourn for a few minutes. No, I'm corrected by my colleagues that since he's been seen in court, you direct the orderlies to bring him here. Yes.
May I say our colleagues who are politicians could do better.
My Lord, can I go out but come back and come back?
Yes?
I think, my Lord, you've made yourself very clear, such that even if you were to go for a break, you'll be released.
My lord,
I'm told
if Honorable Kaluma could move,
by the order that is in this building.
Yes.
Yes. Okay? So pass on to my order in the list. Is that okay?
Yes.
And then it shall appear before the court at Kajiado as ordered by that.
Yes. Yes.
So I shall adjourn at that stage. But if you have any issue, you know my chambers.
Okay. All right. Thank you.
Claim the power and sovereignty of the people of Kenya, that to reclaim the power and sovereignty of the people of Kenya that vests to reclaim the power and sovereignty of the people of Kenya that vests with them.
By donating to number 555155. Support NASA TV. NASA TV, mambo yabadilika.
Tumeambiwa we can enter. We've been told we can enter.